I asked you, what would you be positive for? And you told me marijuana. And I said, and what else? And you said marijuana. And then I said, you're going to be tested. Then you said, and methamphetamine. I'm not going to give you the easy way out. You have an 11-year-old. Is that child with you? I asked you, what would you be positive for? And you told me marijuana. And I said, and what else? And you said marijuana. And then I said, you're going to be tested. Then you said, and methamphetamine. I'm not going to give you the easy way out. You have an 11-year-old. Is that child with you? Court is calling 2022 CR 8646, State of Texas versus Jasmine Ibar. You, Miss Ibar? Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? Yes. Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just like for the court to follow the plea bargain agreement that we'll reach with the state.
All right, Ms. Ibar, do you have any children? What are their ages?
11.
When you're drug tested today, which you will be drug tested today, what are the results going to be?
Honestly, it's really good.
All right. So I'm not going to give you the easy way out. You have an 11-year-old. Is that child with you?
Yes.
You have an 11-year-old. What are you going to be positive for?
No.
And what else?
No.
All right. So we're going to do a drug test today. We're going to see if it's just going to be marijuana.
No.
See, we have an issue here. So why are you being dishonest with the court?
I'm not being dishonest.
No, you were, because I asked you what you would be I asked you, what would you be positive for? And you told me marijuana. And I said, and what else? And you said marijuana. And then I said, you're going to be tested. Then you said, and methamphetamine. So the court has an issue. And let me just tell you what my issue is. And sometimes people say, Judge, I don't understand why you do this. I don't understand, why can't she just do her time and be done with it? The problem is she has an 11-year-old at her home and she's testing positive for meth. She just told me she's going to test positive for meth. So who else is at home with your child other than you? Okay, yeah. So I'm not inclined to give her 58 days in the Bexar County Jail. I mean, if you all want to talk about probation, I'll give her probation. And she's getting drug treatment. I can't have somebody. I don't know why you're shaking your head.
One of the most unforgettable moments of the hearing. Instead of quoting laws or legal rules, the judge tells a simple story about hiring a babysitter. Sometimes the most powerful courtroom arguments aren't legal. They're the ones every parent instantly understands.
I don't know why you're shaking your head. I cannot have someone who is using meth and having an 11-year-old at their home that they're responsible for. That's how children end up getting killed. That's how children end up wandering the streets and picked up by strangers because their parent who's supposed to be taking care of them is not, because they're high on meth. And I don't want to hear that you're a good parent. You know why I don't want to hear that? Because if I were to knock on your door because your attorney or this state's attorney gave a good reference for me and said I would be a great babysitter, if they said, hey, she's the Black Mary Poppins, she'll be great, and I spend time with your child and your child loves me and your child says, yes, I want her for my babysitter, and you agree to hire me, and as I'm walking out the door, I tell you, oh, I may be positive for marijuana, and then when you question me again, I say meth, would you still let me babysit your child? And you know why? Why is that? Thank you. And so that's what I'm dealing with right now with you. You are using marijuana and meth, and you're taking care of an 11-year-old. So counsel, she needs help. And just sending her to the Bexar County Jail, because I'm sure, is this a judgment satisfied?
Yes, it will be.
All right, sending her to the Bexar County, well, not even sending her to the Bexar County Jail, there will be a judgment satisfied. She'll walk out of the courtroom, go celebrate maybe by using more meth and marijuana, go home to an 11-year-old that her mom should be just the grandmother for, but now she's got to be a mother too and keep an eye on her from the 11-year-old. That's too simple for her. So I'd be more than willing to give her probation so she can get help for her drug issues so that perhaps she can be a good mom to her child. So I don't know if you all want to consider that.
I will have to talk to my client about that.
All right. Thank you.
Hi, Your Honor.
Yes.
She will request probation, Your Honor.
All right. Well, you want to talk to the state, see if they're in agreement to her being given probation? And you're asking that punishment be assessed at 2 years in the state jail facility and that the state will recommend community services. Is that correct?
That's correct, Your Honor.
All right. No, that's fine. All right. Miss Ibar, are you employed? And you only have the one child? And what do you do for a living? Okay. And who all lives at the home with you other than your mother, yourself, and your child?
My dad.
And what are their ages? All right. And is Child Protective Services involved in your life? Okay. All right. This is what the court is going to do. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There's to be 120 hours of community service restitution. The court will give you credit for 40 hours if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be deducted. The court is going to require you to do parenting classes with triple T, and the remaining of your community service hours will be waived once you completed that. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors until further notice. I'm going to want field visits, probation 2 times per month until further notice. I'm going to want a TAP evaluation. Follow all recommendations of TAP. If they ask for inpatient treatment, we'll start with intensive outpatient treatment. And either way, I want intensive outpatient treatment. And I'm going to want 90 sober meetings in 90 days. There should be regular reporting by Zoom or in person. And there should be the UA hotline. And she needs to be tested at least once a week until further notice. And tell them she said she used marijuana, so they're going to have to make sure those levels for the marijuana are dropping. It is calling 2024 CR 0059 and 2024 CR 0056, State of Texas versus Larry Evans. Can I have parties announced for the record for the state?
Anna Ochoa Nelson.
Defense.
Andrew Fraley for Mr. Evans.
And are you Mr. Evans?
Yes, ma'am.
All right. In each of the cause numbers, the court has received a motion to amend bond conditions. State, have you had a chance to review the motions?
Yes, sir.
State, are you prepared to proceed?
Yes, sir.
So it appears that his conditions are GPS, full house arrest, and no contact with the complainant. And is the complainant the same in each cause number?
To answer your question, yes, Your Honor.
All right.
If I may, I believe he's on partial house arrest at this time, Judge. He's allowed to go. It's tracking. It's tracking.
Okay. Well, I'm just saying, because that's what it says in your motion.
What date was that motion filed, Your Honor?
This is November. Do you have an updated one? All right. If you could give me a copy of the updated one.
And Judge, it was modified in January.
All right. Thank you.
I'm going to hand you.
All right. Thank you. I appreciate that.
This should be file stamped on February the 6th, the last
Yes.
court date. We also have included motions for speedy trial in both cases.
All right.
Assertion of the right to a speedy trial.
All right. So first things first. So there's a partial GPS for work only, and there's no contact with the complainant.
Correct.
So defense, what are you requesting?
We're requesting the removal of the GPS altogether, Your Honor. My client works at Specs as a delivery driver. And it's impossible for him to go all around. Well, excuse me, not possible. He did work that route. Mr. Evans, would you like to explain better than me?
Yes.
Oh, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Larry Evans,
All right.
Mr. Evans, where do you work?
Specs.
What do you do at Specs?
I deliver liquor.
So when you deliver liquor, you go all around the city, correct?
Yes.
And when you do that, you originally had a problem
Yeah.
with, when you originally doing it with GPS tracking.
Yes.
And then what happened?
I was with some clients and it went off. And so my supervisor said, since it went off, I can't work the route until I can get it removed. And that takes 2 hours from my
Hold on.
10-hour day.
So he said you can't work the route until you get it removed.
Yeah.
So they shifted you to a different
The
position
warehouse.
and you actually lost money based on that.
Yes.
And you every day you're losing money based on that information.
Yes.
And you can, I don't know if the court wants more explanation on how he's losing money, but with those 2 hours, but
Well, I want an explanation on how the fact that he's allowed to work on GPS and it went off and therefore he can't work the route. I don't understand.
do you want to explain?
Well, they said I embarrassed the clients.
Ah, okay.
So they moved him to a position in the warehouse. We would ask that that be removed so he can go back to his original position. I apologize. I'm getting the feedback on the microphone, so it sounds like I'm loud. So Mr. Evans would ask that you remove the GPS tracking. He understands the bond conditions. He understands he needs to stay away from Miss Whitaker. However, with him losing money based on this GPS tracking and the rest of it, that's why we'd ask those to be removed at this time.
All right. State, do you have any questions?
Mr. Evans, have you had any contact with the complainant in these cases?
No more.
Have you had any contact with the family members of the complainants in these cases?
No, ma'am.
Do you, if GPS is removed, do you have any intention of contacting them in these cases?
No, ma'am.
What about the family members of the complainants?
No, ma'am.
No police questions.
All right. Any other witnesses?
No, Your Honor.
All right. The court will hear argument.
Judge, he's losing money. There's no argument from the state that he has had, or has he continued to influence anyone in this case? There's no evidence that he has violated the bond conditions before this, and he has no intention of doing so after this. We are asking for a speedy trial as well for that reason.
Well, no, let's focus on the motion to amend the bond conditions, then we'll get to your speedy trial.
I understand that, Judge, but they go together insofar as that we're asking for this to go forward quickly. We're asking for this to be resolved quickly.
State, are you prepared to go to trial on this today?
Your Honor, yes.
All right. So there we go. We have your speedy trial today.
Okay, so we'd ask for the bond conditions to be removed today as well. Go ahead.
Your Honor, obviously the state will defer to the court. However, it is concerning to the state that we have an incident of June, from the end of June last year. And then we again have an incident from October 22nd of last year. That's a violation of the bond condition to have no contact with the complainant. Now, we did have the opportunity to speak with the complainant a couple of weeks ago. She did confirm that she had not been bothered by the defendant in this case since that October incident. However, we did not have the opportunity to discuss removal of a GPS with her, so we did not have her input on that, Your Honor. But the state does have concerns for that violation of the bond condition initially.
All right. And counsel, I do have concerns as well because there are two cases.
Right,
And the case from that's ending in 0056, when is that alleged to have occurred?
0056 is the violation of protective order?
Yes.
0056, Your Honor, is the assault family second. That was an offense date of June 25th of 2023. The violation of protective order or bond condition, excuse me, is 0059 with an alleged offense date of October 22nd, 2023.
All right. So I'm not inclined to remove GPS. I don't know if tracking will help him, and state if you will have any objections to tracking only.
I don't have any objection to that.
I'll give him tracking only, but I'm not going to remove the GPS. Yes.
On the bond condition, if I'm somewhere and and somebody comes approach me and they tell me she's there and I leave and they cause the problem, I just want to know how I'm at fault. If I'm already somewhere and they follow me or find out where the party at and then I leave and her friend says I did something, how I'm at fault? I don't.
All right. It sounds to me like you're trying to give me the facts of the case as you see those. This hearing that we're having right now is not for me to determine the facts of your case and whether or not something happened or did not happen. Unless you want to do a bench trial, then of course I will hear everything. All right. All right. So really his plea deadline date is scheduled for March 18th, but we do have a murder trial that's up first. So if something happens to the murder trial and he wants his speedy trial, we'll give you a trial today. So if y'all still want a jury trial today, we will give that to you. Otherwise, your plea deadline date is March 18th.
Do you want to have the plea deadline date as March 18th, or do you want to be on call for today, Mr. Evans?
It's up to you. Otherwise, you're due back here on March 18th. So we potentially could give you a jury trial today, or either you can come back on March 18th. Which do you prefer, Mr. Evans?
March 18th.
I'm sorry?
March 18th.
All right. So do you still want to assert your right to a speedy trial, counsel? Because your client is saying that he prefers to come back on March 18th.
I'll defer to my client, Your Honor.
All right. Are you withdrawing your motion for a speedy trial?
This time, Judge, we would ask for the trial date of March 18th.
Well, March 18th will be your plea deadline date.